My name is Jessica Troell. I'm a senior attorney and I direct the International Water Program at the Environmental Law Institute, or ELI. And I am delighted to be joined by these two amazing women on the stage. Cora So from the Kyle Center for Water Policy at Arizona State University and Chloe Ginsberg from the Rights and Resources Initiative are here in the room. We'll also be hearing two pre-recorded presentations from colleagues who couldn't be here in person. Benjamin Kirsch from the UN Food and Agriculture Organization, and Barbara Schreiner, who's the Executive Director of the Water Integrity Network, will have presentations. And Ben, I hope, is online and can answer questions through the chat with us. We're trying to make it all work. But before I introduce you further to these incredible panelists, I wanted to provide some brief background on the growing body of work around water tenure and the critical role that it has to play in ensuring food security, sustainable livelihoods, and climate resilience of rural communities globally. Is my presentation up? Oh, thank you. Aha, there we go. So what is water tenure? I bet some of you are thinking to yourselves. And why do we care about it? So water tenure is, as the definition says, the relationships, whether legally or customarily defined, between people as individuals or groups with respect to water resources. So it's a very broad definition that actually aligns very closely with universally accepted definitions of land and forest tenure. So basically it includes the coexisting, often coexisting, and sometimes easily, sometimes not so easily coexisting, legal and customary systems that determine which rights and duties are held by various stakeholders. And again, as individuals or as groups, as communities holding those rights collectively, and how those relate to one another and to the resource. So understanding how water tenure systems function, therefore helps us to capture how water is actually allocated, used, and managed at multiple scales, and can highlight the gaps between what's supposed to happen according to the law and what's actually happening in practice. Over the past 20 plus years, Indigenous peoples and other local communities globally have really benefited greatly from a consistent application of the concepts of land tenure and forest tenure to their specific situation. There's now broad consensus that the secure community forest and land tenure is a prerequisite for sustainable and equitable land governance and development, and in turn for agricultural and forest-based livelihoods, food security, and climate resilience, among other development goals. And these developments have really tremendously strengthened communities' position within the political economy of land and forest governance, and it's had really tangible positive results. Since 2002, Indigenous and local community advocacy around forest tenure rights, for example, has actually resulted in a global increase of forest area owned by and designated for communities by at least 40%. Despite these demonstrable advances in land and forestry, until recently, advocacy and policymaking processes around freshwater tenure rights has really been a missing but obviously critical aspect of this discourse. But we know that equitable allocation and protection of water tenure rights is particularly critical, and I'll focus today on the 2.5 billion Indigenous peoples and other local communities who collectively, and often again customarily, steward approximately half of the world's land, but hold legal rights to only about 10% of this land and its appurtenant water resources. A significant percentage of these communities, obviously, are smallholder farmers. And by smallholder, I mean operating on less than 2 hectares of land. 77% of these farms are in water-scarce regions, and less than 1/3 of them have access to irrigation. Additionally, nearly 1/3 of the global population depends on forest goods and services for their livelihoods, food security, and nutrition. For many of these communities, the security of their water tenure for these livelihoods and food security hinges on the interface between customary laws and government-issued laws that may or may not recognize their customary rights as valid. Their water resources are also under increasing threat from unsustainable development, land use changes, ecosystem degradation, deteriorating water quality, and major demographic shifts, all of which are exacerbated by climate change and the impacts of climate change. So in order to ensure both water and food security for these communities, it's essential to have a clear understanding of What rights are most essential to freshwater security for these communities? How are those rights recognized and protected across diverse contexts? And how can we unpack the ways in which water tenure relates to land, forest, and other resource tenure right systems, both under law but also in practice? So to start to fill some of these gaps, in 2016, my organization, the Environmental Law Institute and the Rights and Resources Initiative, what Chloe is representing today, started to develop a globally comparative water tenure assessment methodology, basically to define what water tenure is, what are the rights that constitute water tenure for communities, and then track the legal recognition and protection of those rights for Indigenous peoples, Afro-descendants, and other local communities holding their rights collectively globally. We applied this framework to 15 countries across Africa, Asia, and Latin America. And I just want to really quickly highlight some of the higher level findings from this work to frame some of the discussion that we'll have throughout the rest of this session. You can see that's the publication right there. If anybody's interested, we can get you a copy. The first key finding that I really want to highlight is that, not surprisingly, Indigenous and community-based rights to water frequently depend on communities' legal rights to land, forests, or other territorial rights. In some countries, we found that this land-water nexus, and I'm using land-water to broadly cover land and forests, actually serves as the only source of legal water entitlements for communities. So the water law doesn't recognize their rights, only a land law or a forest law does. The ways in which these land-water nexuses are created are very diverse. So they can come from land, forest, agricultural laws, constitutional recognition of indigenous territories, administrative laws, and others. In many cases, these sectoral laws, again, unsurprisingly, don't speak to one another. So we see land and agricultural laws frequently mentioning water only in passing as part of broader resource rights systems, or part of broader set of resource rights. And water laws, on the other hand, rarely, if ever, I've only seen a couple of countries, speak directly to the legal status of communities' customary or collective water resource rights. So while these nexuses actually provide us with new and possibly innovative avenues for communities to assert their water rights, the contradictions or lack of clarity across different laws can leave those rights open to legal challenge. Ultimately, that undermines both the water and food security of those communities. So there's a really pressing need, and we hear this from every corner, for improved intersectoral legal harmonization in order to ensure communities' water tenure security. The second finding I want to highlight is related to women's water tenure rights in particular. Unfortunately, of all the indicators, this one was the worst in showing. We found that women's water use and governance rights were recognized in less than a third of the identified tenure regimes that we analyzed. And in most cases where their rights are recognized, it's in land and forest laws. It has nothing to do with water laws. So there's really an urgent need for the water sector to rethink how we're highlighting and specifically protecting women's water tenure rights. The fact that water laws are generally gender blind, often they're protected under equal protection clauses or other constitutional provisions, but there's no specific water rights for women. So we say that's gender blind, means in practice they often reinforce existing gender inequities and discriminatory cultural norms. So we've done some actual follow-on research from Whose Water here to unpack the land-water nexus and the forest-water nexus, as well as some of the inheritance and marriage laws and other things that really contribute to women's water tenure security across a bigger number of countries, and Chloe will share those findings with you in just a couple of minutes. The third key finding I wanted to share with you is related to the legal recognition of customary water tenure. So on the good side, 82% of water tenure regimes we analyzed recognize communities' customary water rights. But again, this is usually a blanket recognition of broader customary rights or territorial rights, and is not about specific water rights. More often it's based on, at the constitutional level or in a specific law related to a specific group. So again, highlighting the need for better integration and alignment across the relevant sectors. But based on these findings, I also wanted to highlight that the IMI, the International Water Management Institute, and ELI have done additional research unpacking the legal pathways in which sub-Saharan African countries provide recognition for customary water tenure rights in their national laws, and have been able to kind of highlight some of the key challenges that we see looking forward around how do we not freeze what is essentially living law of communities that is adaptive to their local circumstances by recognizing it at the statutory level. How do we align those two? And again, sort of the broader question around the politics of recognition. Who should have the authority to recognize customary rights or to deny the recognition of customary rights in the first place? So I'm happy to share that work with you as well. Second to final, sorry. One key finding that we had that, again, our colleague Barbara will talk about this in a little bit more detail in her presentation, is that with respect to ensuring that communities have sufficient water for livelihoods, including agricultural livelihoods, we found that existing systems for administering water rights are absolutely not tailored to the needs and capacities of Indigenous and local communities. Most countries on a lot of this is sort of a post-colonial remnant of permitting systems that came in and were imposed on countries, and then they maintained those systems afterwards. But most countries administer water rights through permitting and licensing systems. And almost always they facilitate access to use for water for domestic purposes or basic human needs by exempting communities from having to get a permit or a license for those uses. But when it comes to productive uses for livelihoods, sometimes little ones are included in that exemption. A small number of livestock, for example, or community gardens can be exempted for basic food security for the household, basic security. But anything that's productive usually requires a permit. And this can really be a burden on communities in terms of the financial costs, the need to travel to be able to do this, the fact that they don't necessarily even know that they have these administrative requirements. And more importantly, governments who have imposed these requirements don't have the capacity to implement and enforce them on the vast number of rural users that they're supposed to be regulating. So this results in a situation where a great number of water users are operating effectively illegally outside the law. They're supposed to have permits for what they're doing, but they don't, and it's not necessarily their fault, but that doesn't really matter. And even where they're getting their rights exempted for certain uses, take that to court. There's no tracking, no recording of those rights. Nobody has any idea. So when a company invests upstream and they are claiming that their rights are being infringed upon, they just say, well, we use the water we use. Prove it, So it's very tenure insecure situation. Finally, I would just highlight the the pervasive lack of specific procedural guarantees for communities with respect to their water rights. What I mean by that is the right to access information that you need about developments or decisions that are going to impact your water rights, the right to participate in those decisions, and then the right to access redress or the judicial or justice if you have your rights infringed or extinguished. Those are never really clearly announced at the level of national water laws, and it's really often discretionary for the water administration to decide, is it needed, when is it triggered, how much consultation do we do, and of course it becomes a checkbox undertaking, and there's very little meaningful consultation. So that's a really huge missing piece in terms of whatever the state of recognition of the water tenure rights, to be able to protect them. This is what communities need to have much more clearly laid out. We'll hear more from our colleague Benjamin Kirsch, who I hope is online right now. As we move forward in this, we're kind of taking the findings from this work, from the work of colleagues. We've developed a water tenure experts group through the FAO that has been meeting since 2019. And through that group, we've exchanged research and really built sort of a case for the fact that there needs to be a lot more guidance for countries, as there is for land, forest, and fisheries tenure, on how do they responsibly govern their water tenure resources. So back at the UN water meeting, the last UN water meeting, FAO announced that they're going to be supporting a global dialogue to develop principles for the responsible governance of water tenure. We have a zero draft. We're going to do a consultation in Rome next month on this, and then hopefully it will be coming to a consultation near you. We'll be doing regional, national, and other stakeholder-based consultations to develop these principles that hopefully can help guide countries along with additional guidance materials and technical papers and things like that. These are some of the publications that are available to kind of dive into this research if you're interested. We continue to try to expand our understanding through water tenure assessment. The one that RRI and ELI has created, plus FAO has another national level water tenure assessment methodology that we've been working on and refining across 5 different countries to really get the evidence base up and understand where the critical issues are and how can we target policy and legal reform and support communities in their advocacy efforts over time. So I will stop with that. That sort of sets the, I hope sets the stage for what is it that we're talking about. Where are we now? But I'd like to thank you and introduce our next speaker. Cora So, am I saying that right? Mm-hmm. Good. Is an enrolled member of the Navajo Nation. She is of the Reed People clan and born for the Black Streaked Wood clan. Her maternal grandparents are of the Bitterwater clan, and her paternal grandparents are of the Red House clan. She was born and raised in the Navajo Reservation and is originally from Shanto, Arizona, and located in northeastern Arizona. Cora works now at the Arizona State University's Kyle Center for Water Policy as a senior research fellow, researching, analyzing, and developing recommendations for Arizona tribal water policy, and collaborating with tribal leadership and representatives, state government agencies, and other stakeholders in connection with the Arizona Water Innovation Initiative. So I am absolutely delighted to have Cora here to share her vast experience on how do we push forward in recognizing tribal rights, whether registered, and I will let you.
Thank you. Thank you. Good morning, everyone. My name is Cora So. I'm very happy to be here with you all. I have a bit of a smorgasbord of information, so feel free to follow up after if there's anything that you have questions with. But to start, I wanted to provide, how do I go forward?
Green.
Oh, sorry. Give context to some of the work that I do. So as Jessica mentioned, I come from northeastern Arizona. It's the orange part of the Colorado River Basin. My family lives just below the demarcation between the upper and lower basin of the Colorado River Basin. I currently reside in Phoenix, where I do state tribal policy work, tribal water policy work. But to give context to some of the work that I do in water tenure, in the realm of water tenure within the Colorado River Basin, there are 30 federally recognized Indian tribes that reside within the basin as a product of the law of the river, which is a combination of federal law and different state laws. The settlement of tribal water rights within the Colorado River Basin comes from each state's water allocation. So there are 7 states within the basin. Each state was apportioned a certain amount of Colorado River water in the late 1900s. And of that, each state's allocation must have some apportionment for the resolution of tribal water rights claims, meaning those tribes within that state have to resolve their water rights claims from their state's apportionment. Majority of the tribes within the Colorado River Basin are located within Arizona. As of now, 26% of tribes within the basin have recognized rights to their water, but this does not necessarily correlate with full access or proper and fair access, and we can talk more about that as well. The unresolved tribes within the basin, their claims exceed the current amount that is currently available from the Colorado River by several orders of magnitude. So we are in a deficit, and each state has to figure out how to free up water to resolve claims for certain tribes within their state. 11 of the 30 tribes have unresolved claims, and 10 of those of which live in Arizona. So there's a lot of opportunity within the state to settle the remaining amount of claims within the Colorado River Basin, and all of the different tribes have a unique history and fight in securing their water rights. Within the state of Arizona and most of the West, we do follow a prior appropriation legal system, meaning first in time, first in right, and the unique nexus with land possession is really important in the context of tribal water rights claims. This visual shows the history of the federal Indian policy timeline on the left, as well as in comparison to some of the more prominent notes of history in Western water development, particularly within the context of Arizona. And as you'll see, pre-contact, pre-European development, Indigenous laws and practices were regulated by local tribes, and that's the customary law that each individual tribe still practices through different cultural events and seasons, and is passed down generation to generation. And I think is something that is more currently being seen through traditional ecological knowledge, and still is regulated for those tribes that do have water access on their own land. Some tribes have water codes and different water laws that regulate based off of their tribal laws and cultural practices. That is seen and recognized as the law of the land within the reservation boundaries. And so it's very unique. My tribe in particular created our tribal water code in the 1980s, and so it's very helpful when we're negotiating settlements in regard to management of water and how we work with non-tribal and neighboring communities in the practice of protecting our water rights, because we have this defined water code to look back on and use as a starting place in negotiations. But some of the work that I do analyzes this history in the context of federal Indian policy. And when we talk about water rights, tribal water rights, we're not only talking about water law in the sense of the prior appropriation system or the riparian rights system that we have in the United States, but we're also talking about Indian law and policy. This history is still current, and the laws that were formulated in these different eras of federal Indian policy still exist, and we as tribal nations have to work with these laws, even though we're now in this era of self-determination and self-governance. And this, of course, is from the perspective of the federal government. The federal government maintains a trust responsibility to all federally recognized tribes, 574 to be exact. And this is a legal and political relationship that each tribe has with the federal government in cession of their individual lands. They created treaties, contract legal agreements with the federal government to maintain certain rights, and that is in perpetuity. And so this is where our water rights are derived from. And of course, this was established in a time when the new federal government was being established, but looked to tribal nations as sovereign to sovereign, government to government. And it's over time that you see this federal Indian policy shift like a pendulum swing to times where the federal government outright terminated the legal and political relationship they had with tribes. Of course, this resulted in land loss and displacement for Indigenous peoples. And then resulted in the reservation system that we currently have now. It also included, as you'll see in the late 1800s, this period of allotment and assimilation. In the formative years of the relationship between tribes and the federal government, although tribes had signed hundreds of treaties with the federal government in the 1800s, these treaties were collectively seen as the legal pillar for the communication between the federal government and the individual tribes. However, the federal government also had competing federal policies encouraging homesteading and settlement out west. Oftentimes, these competing federal interests provided conflict for the local tribes, and the federal government had a sort of protective duty, a trust duty to protect the resources of each tribe, but this oftentimes was still developing in these formative years, and you'll see that as whatever administration came in had a large portion of control into what the federal policy would be. And so you have federal acts like the Indian Appropriations Act in 1851, which appropriated lands to tribes and freed up lands and allowed surplus land to be sold off to non-tribal settlers at the time. Apart from these treaties, these land exchanges really dispossessed tribes of their traditional homelands, but also their access to be able to advocate for their rights to water, because at least in the West, we associate water rights with the land that you have, and of course, the riparian rights regime as well. And so the Homesteading Act of 1862 allowed U.S. citizens and immigrants to claim 160 acres of surveyed federal land for a small filing fee, and these claimants were required to improve the land and to live on the land to gain full ownership. The federal encouragement of the settlement of the American West resulted in a transfer of 270 million acres of public land to private individuals in the West. This dispossessed many tribes and ultimately dispossessed them of their way to fully establish their water rights in the West. So as I mentioned before, we do have a number of tribes that still are fighting to resolve their water rights within the West. This is just within the context of the Colorado River Basin where I do work. But we do have a panel later today with a representative from the Winnebago and Ho-Chunk tribe in northeastern Nebraska, who I think could give a regional context to some of this work. But I think the ending remarks that I want you all to leave with is that in the context of tribal water law and water tenure, we're working not only with the history of disposition and colonization through these laws that are still on the books that we still as tribal nations have to work with, but we're also working with shifts in administrations at the federal level and also at the state level. So not all states recognize and want to protect these relationships that tribes have with the federal government or with their own individual state. So it is a very dynamic approach to protecting tribal water rights. And of course, each tribe is unique and has its own management system based off those customary laws, but also based off of modern water management practices as well. Thank you so much.
Thank you so much, Cora. That was awesome. Thank you. I think, yeah, what you took away, I was actually scribbling some notes and thinking you've really set the scene for sort of the inherent contradiction of working on this from a higher policy level, which is it's so unique to place. It's so place-based, and particularly when you're talking about working with customary provisions and specific communities and their historic practices, that taking the historic context and maybe even the need for redress and redistributive justice into account. I work in South Africa a lot. That comes up there, and Zimbabwe. But at the same time, we do see these linkages across even North America and places globally. The role of partnerships, and really having the necessary understanding and having a real meaningful place at the table to be able to advocate on an ongoing basis for these rights is a critical aspect of it. And the fact that, unfortunately, having rights recognized does not actually mean that they're implemented in practice. And then we see that in a lot of different places as well. Struggling in Latin America right now, one of the greatest court decisions that we've seen in a long time was in the Atrato River Basin, where it was recognized that even legal mining that had taken place in the river had polluted it so badly with licenses. The Constitutional Court basically said that's in violation of the indigenous community's human rights, and created what they called biocultural rights that brought together the communities and the rights of the river. And it was this incredible idea where they appointed members of the community to redress this and work with the company and the government. And we've seen very little progress in implementation and enforcement. So, starting with the legal basis, but also always with the eye towards, okay, how do we make this function in practice? How do we equip communities with the advocacy tools and the legal tools that they need to actually make sure that this is pushed forward? So thank you so much for sharing your experiences. We're now going to have our first of 2 pre-recorded presentations. I'm going to just briefly give you an introduction to the next speaker. If I can find her bio, sorry. Barbara Schreiner is the executive director of the Water Integrity Network based in Berlin. She has over 30 years of experience in water management in developing countries and focuses on good governance and addressing poverty, inequality, gender, and other forms of social and economic marginalization. Before she was at WIN, she was executive director of the Pegasus Institute and has worked internationally as a consultant. But importantly, she was also the Deputy Director General for Policy and Regulation in the original Department of Water Affairs in post-apartheid South Africa. She was also advisor to 3 water ministers in South Africa. So she comes with just an incredible perspective across time and different positions. So we'll hear from Barbara online now.
Good day, everybody, and thank you very much for the opportunity to talk to you in this important session and to contribute some of my ideas. And my apologies for not being there with you. I promise I would much rather be in the room with you. But being that as it may, modern technology enables me to at least engage with you. Let me begin by asking 3 questions. How many small-scale irrigators are there in Southern and Eastern Africa? How much water do they use? And how are their water rights protected in law? The answers to the first 2 of those questions are difficult to come by, but the third question I will be addressing in this presentation. There are around 33 million small-scale farms in sub-Saharan Africa, many under 1 hectare in size. Not all of those are irrigated. In sub-Saharan Africa, an estimated 40 million hectares is suitable for irrigation, but only 7.3 million hectares is actually under irrigation. Sub-Saharan Africa is the only region globally where the per capita production of staple foods has declined over the last 50 years, and where major famines still happen, generally triggered by drought and increasingly by the impacts of climate change. A number of those smallholder farmers themselves are food insecure. In this context, small-scale farming is critical to food security across the continent, and more reliable access to water, particularly through smallholder irrigation, has huge potential to reduce hunger, raise incomes, and improve development in the region. So we need to increase irrigation among smallholder farmers. And yet this is often a sector of farmers that are largely invisible to water managers. Across the region, the use of permits for the abstraction of water, whether it's surface or groundwater, is a common legal approach, even for small-scale irrigators. Water permit systems are generally seen as the modernized way of recognizing water tenure, and therefore a good thing to put in place. But do they actually achieve what they intend? What do they intend to do? For the state, 3 things. Enable the state to control who uses how much water where and for what purposes. Enable the state to have information on how much water is being used, where and by whom, and under what circumstances. And enable the state to charge for water use. For the water user, the intention is that the permit system provides protection of water use and clarity on the terms and conditions under which water may be used. Permitting systems across sub-Saharan Africa fail to meet these intentions, both for the state and for the water user. In 2016, Uganda had issued 1,320 water use permits. Kenya, just over 4,000, Malawi, just over 3,000, and Zimbabwe, just under 11,000. If we take Uganda as an example, in 2024, they received 689 new permit applications, and they issued 432 permits. That was both new permits and renewal of old permits. Remember, water use permits are generally time-bound and need renewal. They assessed in the region of 200 permit applications. Not only are they not keeping up with the permit applications that are coming in, But there are 3.5 million family farms in Uganda. If only 2% of those are irrigating, say 2 to 3 hectares, that makes 70,000 permits that should be issued and enforced. At a rate of 400 a year, in the time since 2016, they will have issued around 4,000 permits, new and renewals, making a total of just over 5,000 permits, give or take. Let's be generous, say it's 10,000 permits. You see the scale of the problem. Across the region, one sees a pattern where large amounts of water are used by small numbers of people and relatively small amounts of water by large numbers of people. But the tendency is to treat them the same under permit systems. The majority of small-scale users across the continent don't know that they need a permit to irrigate, or they don't care if they do know. And the state doesn't have the capacity to A, ensure that the large number of small-scale users all have permits, and B, that the large number of small-scale users are complying with the terms of their permits. I don't have time to go into the issue of collecting water use charges from a large number of small users and the cost effectiveness of this approach. It's an important discussion, but one for another day. So is the discussion on how the system is corrupted and bypassed. In Nigeria, for example, I recently heard how borehole drillers have been caught taking one permit and using it to drill up to 10 boreholes on that one permit. The reality is that these permit systems exist in a context of limited state capacity, both financial and technical. As a result, from the perspective of the state, the intentions of the permit system are not well achieved. From the perspective of the small-scale irrigator, strictly speaking, their water use is illegal, and they have no legal protection in the face of increasing competition for scarce water resources. In one sense, what permit systems have done is to criminalize poor rural farmers and enable wealthier, more administratively competent large water users to cement their legal rights to water through permits. Many of the small-scale irrigators are operating within customary practices, customary land tenure and customary water practices. While customary land use has been relatively widely accepted, customary water tenure, particularly in the African context, has been particularly poorly recognized. In some Latin American countries, the water rights of indigenous communities have been given statutory recognition, although often in land and forest law, not water law. But in sub-Saharan Africa, there is little such recognition. But why does it matter? Why don't we just leave it as it is? People are getting on and using water with or without permits, and perhaps it's just best to let it be. In South Africa, for example, IMI, the International Water Management Institute, identified 70,000 hectares of small-scale irrigation in Limpopo province that the Department of Water had no record of. Is it not best to let sleeping dogs lie? There are those who make this argument. Don't rock the boat. Just let small-scale irrigators get on with it. Let them use the water that they do. Let them operate outside of a system that doesn't serve them well. I'm not so sure. Firstly, competition for water is increasing across Africa, even as climate change is affecting water availability. Africa is the most water-stressed continent, and conflicts over water are rising, as are forced displacements due to droughts. Who has access to water, when and how, is going to become increasingly contested. Secondly, as an ex-bureaucrat, once responsible for issuing water use licenses in South Africa, the failures of permit systems irk me. We should design systems that serve the needs of everyone, not ones that we make work by ignoring large parts of the system. We can do better. A system that does not treat everyone fairly fails the test of procedural justice, which emphasizes the importance of treating individuals equitably and ensuring that decision-making methods are unbiased, consistent, and respectful of individual rights. A system that is out of reach for the majority of people for whom it was designed, in this case small-scale irrigators, fails to meet the requirements of procedural justice. It also fails the test of distributive justice. Distributive justice is about how goods, wealth, and privilege should be allocated amongst individuals, and raises important questions about fairness and equality in the distribution of resources and opportunities. If the system enables the water use of the rich, powerful, and administratively competent, and in essence criminalizes the poor. It cannot be said to meet the needs of distributive justice. Is it possible to design a different system? Yes, of course. It requires a decolonized vision that recognizes that water tenure in the rural areas of sub-Saharan Africa operates largely under customary or communal rules, that recognizes that much of the current water legislation in sub-Saharan Africa still carries the imprint of colonial legislation and the colonial vision of experts from the global north, even now. It requires a revision of the system to meet the African reality, which includes the reality of customary practices on the ground. A hybrid water rights system would go a long way to addressing the issues of procedural and distributive justice and to meeting the needs of small-scale irrigators and the state alike. A system that uses the extremely useful tool of water permits to control the water use of the small number of large water users who either abstract large amounts of water or who are responsible for significant pollution of water resources. A system that recognizes the customary water use practices of a large share of the population. A system that recognizes, protects, and supports the water use of the critical small-scale irrigators across sub-Saharan Africa. A system that is based on African practices and realities, not those of the global north. Thank you very much, and I hope that there's going to be a very interesting discussion following all the presentations. Thank you.
So much. Barbara's particularly awesome. I have done a little bit of the work that she's talking about with her. I will do she's on a plane from Uganda to Berlin right now. Otherwise, she would join us online. I'll do my best to answer any questions that you might have related to her work. But we wanted to stop talking at you for a few minutes before we continue our presentations and give you all a chance to ask questions and also contribute maybe your experiences in work relevant to water tenure. Anyone have any questions in the back? Hang on. Jude's hoarding the mic. Yeah, no, it's great. Thank you so much.
Just a question following up. I thought the presentation was really interesting from Barbara, and I was curious about an alternative approach of using sort of this tenure and tenure right system for groups of users that then have a more, so then it's rights allocated to user associations that then allocate those rights, as opposed to trying to deal with every one of small hectare producers, and whether, I don't know the South Africa situation, but that's used in some places, and I was curious about that as an opportunity.
It's definitely an opportunity, and actually back in the time when South Africa was writing its national water legislation, it was conceived of as there were different types of permits, and having these group-based permits or landscape-based permits were very much integrated into that, and that was the vision. What's happened, however, is that actually getting the water out of the large-scale agricultural users and to those people has not happened in over 20 years. And there's lots of court cases, and it's been bogged down, and it's just not functioning in practice. And I would say we looked a lot in Who's Water as well at sort of the role of irrigation user associations, water user associations as collective mechanisms for water tenure rights. And sometimes it functions really well, sometimes. But often they come from here, and they get imposed onto the communities, and they don't recognize existing institutions, and they don't recognize existing practices, and they aren't aligned with those institutions and practices. So often you see that the most, I liked Barbara's words, administratively competent people within a community are those who wind up in charge and having the vast majority of control over those water rights, or who have the money, obviously the resources to be able to control that. So, I mean, in theory, yes, and there are safeguards, again, where we can talk about how to get women more engaged in user associations and all of those wonderful things, but in practice, and in my experiences living in Malawi and Zimbabwe with these situations as well, it's very difficult in reality to track, to have these top-down processes actually be accountable in any kind of meaningful way. Although, obviously, you know, they work for the farmers that get to be part of it. So I hope that answers your question. We are working actually right now on revising the South African Water Act. That's part of what we're trying to do to get around some of these issues. In the back, Doug?
I'd like to add a comment on the experience of the Water Act in South Africa, because I started the IMI office there and worked with Barbara when she was still with the Water Affairs Deputy Director General. And what struck me was they had the opportunity to be radical, and they chose not to be. And I kept pushing them, you know, why don't you try things, you know, to see if it works? And they were so afraid of breaking the legal rules and all this kind of stuff. And of course, the better placed people, the big white farmers and so on, took advantage of that. Now, it's a balancing act, because they didn't want to undermine what was working economically in agriculture in South Africa for the white folks, and as a, you know, a big employer and so on, was working. But the other part of it is they didn't link it to land tenure reform. Mm-hmm. It was seen as a separate thing. And it was a missed opportunity. And if the South Africans now have the courage, if they're going to revise the act, to get radical again, maybe they can make some adjustment in this, because it was a lost opportunity. And
Thank
Barbara
you.
would probably agree with me.
Oh, she would absolutely agree with you, as would Robin Stain, who I work with right now, who is one of the authors of the Water Act as well, who we're working to kind of think through, how do we get more radical? How do we end run these large-scale interests and really get redistributive justice? And you're right, one of the key missed opportunities, as is honestly, I would say, the most important challenge in water tenure more broadly, is the failure of countries to link the land and water planning, management, and allocation systems, and all of the impacts they have on each other. It's difficult. It's not an easy problem by any stretch, but it's absolutely critical. Thank you so much. I can take another question, and then we'll have, yeah? Oh, sorry, 2 more questions. You go first, and then, not to put you last, Tony. Save the best for last. Right here.
One of the issues in South Africa and the African countries is that there's not very much irrigation compared to other, you know, and the people who are the smallest, the people at the bottom of the picture, are not using irrigation very much. But if they do, there'll be a change in the complexion of water use overall. And of course, we focus, when we look at very small farmers, on the quality of the water, because it's also drinking water, and it has an impact on the health. But there's a scale situation that would develop if smallholder farming became more irrigated. And I wonder if that's taken into account in all the work on the legal situation.
Absolutely. No, I mean, there's always a balance, right? And I think the idea of one of the things that we're trying to work on with FAO right now is coupling water tenure assessment with water accounting and analysis, you know, within specific basins, because where the data doesn't exist on that, how much is being used, what are the trends, what are the projected uses, then we can't make good decisions about trade-offs and allocations. Because again, well, you know, especially with climate change, right? I mean, having tenure security is about legal certainty. At the same time, we have to balance allocation with the need to reallocate under systems of shortage or drought. And what does that look like when it comes to guaranteeing water for livelihoods, basic human needs, versus allocating to larger scale users with more economic, you know, impact? And it's a hard question, and honestly, it's up to every country's policy priorities. But at the very base, we're kind of arguing there needs to be a prioritization of water rights for basic human needs and livelihoods, so that food security and, you know, basic productive uses can be guaranteed within those allocation processes, with the kind of procedural guarantees that you need so that communities can protect those rights. Because even if we, increase the use by this much, it can be a huge impact in some places, and that will have to be taken into account. But often still doesn't compare to some of the bigger users that are, abstracting. So I hope that answers your question. Yeah.
Yeah, well, first of all, thank you so much for these presentations. I guess the phrase that comes to my mind is good faith negotiations. And so I guess
Free, prior, and informed consent. Yeah, no.
yeah, so really how do we move forward in the absence of that? How do we build that? Is that, especially in the case of tribal nations, do you guys feel like there is good faith negotiations kind of as a starting place on both sides? And if not, how do we get to that foundational starting point?
I think you can still, does it still work?
Oh, do I need the mic?
Does she need the mic, or is she still on?
Do I use this? Yeah. Thank you for the question. I definitely think that throughout history we've seen that trend of bad negotiations, and I think the policy and legal frameworks that are still in place may sometimes encourage that. But we do see progressive state policies that help facilitate these conversations. In particular, in Arizona, we have had 2 examples of different political administrations that have helped the progress of tribal settlements or hinder them. And so in our previous governor's administration had a state policy that restricted tribes' ability to bring more lands into trust status, meaning federal trust status, land back, progress that tribes wanted to reclaim for themselves as a condition of settlement for tribal water rights. And so that was a non-starter for tribes within the state because of this history of disposition. There is this movement to bring ancestral territories back into tribal jurisdiction and tribal governance. And so that was just a non-starter for those negotiations. But then we have a new governor who, within the first, I believe, 6 months, rescinded that state policy, and we have now 4 tribes that have their settlement in Congress for authorization. So we really do see how I think more progressive stances and approaches in these negotiations help the progress of settlements. Unfortunately, tribal water rights settlement negotiations don't have any regulations, as do other areas of federal Indian law, like Indian gaming. We have very specific Indian gaming laws from a federal perspective that kind of put up those frameworks for how we negotiate compact renegotiations. And so we don't have models like that in water. So those could be also starting points of just putting in those frameworks for more equitable negotiation conversations.
I would just add to that I think this process of establishing principles for countries to follow for the responsible governance of water tenure is getting at exactly what you're talking about. How do we have countries negotiate and come to a consensus on a set of guiding principles that are based on transparent decision-making, accountable decision-making, that look specifically at how do we guide investments, large-scale agricultural and other kinds of investments and their impacts on communities' water tenure rights. That's what we're in the process of really trying to negotiate right now. I don't know if you're familiar with the VGGT, which is the voluntary guidelines on responsible governance of tenure for land, forest, and fisheries. But that has been an incredible instrument in terms of policy coherence over the last 15 years, basically, where countries negotiated their voluntary commitments. But behind them has been this force from FAO and other partners to build capacity, to get funding, to help with building the kind of governance instruments and capacity on the ground and advocacy capacity necessary, and multi-stakeholder platforms to make sure that these kinds of things are happening in good faith and to end run corruption. But it's a tough nut to crack for sure. We're gonna have much more time for questions in just a little bit. I want to let my colleague Chloe talk. Let me introduce you to her really quickly. Chloe Ginsberg is Associate Director of the Tenure Tracking Program at the Rights and Resources Initiative, which monitors progress and the legal recognition of Indigenous peoples, Afro-descendant peoples, local communities, and women within these communities' rights to land, forests, and fresh water around the world. For the past 10 years, her work is focused on identifying global trends in community tenure and the implications for these for achieving global climate and sustainable development goals. So I am delighted to have my good friend and colleague talk to you about the gender work that has come out of the Whose Water work we initially did.
Thank you, Jessica, for that introduction. So as Jessica mentioned, I work with the Rights and Resources Initiative, which is a coalition of over 200 rights holder, partner, and collaborator organizations and their allies around the world that are all advocating for Indigenous peoples, Afro-descendant peoples, and local communities' rights to lands, forests, and resources. And I lead the tenure tracking program, which is responsible for monitoring progress in the legal recognition of Indigenous, Afro-descendant, and local communities' tenure rights around the world. And we do so through maintaining both qualitative and quantitative databases, some of which go back to 2002, and which monitor both the specific legal rights that are recognized by the national laws of over 70 countries, as well as the areas of both lands and forests to which Indigenous, Afro-descendant, and local communities have recognized rights around the world in order to track the current status and progress of those rights and the implementation of those rights, as well as the specific recognition of the rights of women within communities. So through that past research, we've been able to show that Indigenous, Afro-descendant, and local communities customarily own and manage at least 50% of the world's land, but our latest data shows that they legally own just over 11% of land globally and have some more limited management rights to another 7% of lands. And just 24% of forests within 33 countries in Africa, Asia, and Latin America are owned by communities. And this is particularly notable because for forest-dependent communities, it's been shown that their stewardship is critical for forest outcomes. And what this really means for our conversation today is that Indigenous peoples, Afro-descendant peoples, and local communities are frequently accessing, using, and making decisions about the water resources that are pertinent to these vast lands and resources that they steward. But as we've already heard from Cora, from Barbara, from Jessica, they don't always have the legal right to do so, which is not only critical for their ability to exercise good and effective governance, but also to seek remedy when their water rights are violated. So as Jessica gave a bit of an introduction earlier, RRI and the Environmental Law Institute have been working together since 2016 to develop and apply this bundle of rights methodology that allows for assessing the right, identifying and assessing the rights most critical for securing Indigenous, Afro-descendant, and local communities' water tenure and water security, as well as the rights of women to community freshwaters. So this resulted in the 2020 report, Whose Water, that Jessica already mentioned, which was published in 2020. And that showed that it really showed that the frequency and importance of the land-water nexus as a pathway for communities to access collective freshwater rights. In so many situations, we did find that it was not generally the water legislation that was providing recognition of communities' collective water rights. It was the constitutions, or it was the laws on recognizing customary tenure, or the Land Act or the Forest Act. So building on that learning, we wanted to take the opportunity to draw on RRI's longstanding global data sets on the status of community-based forest tenure to better understand the frequency with which the legal frameworks that recognize community-based tenure, so we're calling those community-based tenure regimes, or CBTR, as you might see on some of these slides, to understand the extent to which these CBTRs regulating community-based forest tenure can also provide recognition of community-based water rights, and whether women's rights are protected in that. So our latest, we recently conducted an analysis in 2024 that assessed both the strength of communities' forest tenure rights and the specific rights of women to membership, governance, inheritance, and dispute resolution across 104 distinct legal frameworks identified across 35 countries in Africa, Asia, and Latin America that contain 85% of the forests in those regions. And alongside that analysis, we sort of approached from a different perspective in Whose Water, where we more so started from the water legislation and expanded into community rights legislation where appropriate. In this, we looked at over 800 national laws and regulations that are recognizing community-based forest tenure rights to identify the extent to which there's also a basis for the recognition of communities' rights to access, use, and govern freshwater, and whether those are explicitly gender sensitive. So this is just a map of the countries that are included across the 3 regions. And the three indicators that we looked at were first, whether community rights to access and use freshwater are explicitly or implicitly recognized by the laws comprising the community-based tenure regime. And then secondly, whether community rights to govern freshwater were explicitly or implicitly recognized by those laws. Then lastly, we looked at whether those provisions that were recognizing rights of collective rights of access, use, or governance were gender sensitive and explicitly recognized women's rights to use or govern and/or govern freshwater. So this report is going to be coming out this summer, but we'll give you a preview of our findings. So what we found was consistent with past RRI and past RRI and ELI analysis that has shown that legal frameworks recognizing stronger rights for communities, and particularly that recognize community forest and land ownership, also tend to provide stronger and more frequent recognition of the membership, governance, inheritance, and dispute resolution rights of women within those communities. The vast majority of the community-based tenure regimes that we analyzed explicitly recognize communities' rights, that explicitly recognize communities' rights to govern water. The vast majority of those are classified under our statutory framework as owned by communities. And this chart shows that as the strength category 3 would be the strongest ownership of community rights that are considered community ownership of their forests. And in those circumstances, we saw more frequently that there was an explicit recognition of communities' rights to access, use, and govern freshwater. And alongside that where community ownership rights are recognized. That was the best bet for recognition of women's rights, although that was still exceedingly rare and only was explicitly recognized in one country. So some of our additional takeaways from this analysis, as I mentioned, 2/3 of legal frameworks explicitly recognize communities' rights to access or use fresh water, but just over half of those go further to extend those rights explicitly to governance. Less than 1/3 of legal frameworks can be interpreted as implicitly recognizing communities' rights to use or govern freshwater based on the way membership is recognized within the community and governance procedures that are established. And just one country that explicitly recognizes women's rights to community freshwater. And generally speaking, the widespread existence of provisions that at least implicitly recognize both communities and community women's rights to use and govern freshwater can really provide a critical basis by which communities can advocate for their freshwater rights outside of the confines of water legislation or water institutions. And I think these, we've been hearing, I think throughout this conference already about the importance of taking a cross-sectoral and multi-sectoral approaches to both reform processes and to implementation. And as Jessica mentioned previously, that there is often a really significant disconnect between the legislation regulating terrestrial or territorial rights and water laws and regulations specifically are often quite silent on both community rights and very specifically on they're typically gender blind. So we see this as an opportunity to promote alternate pathways by which communities can advocate for those rights and feeding into the ongoing water dialogue. Thank you.
From Benjamin Kirsch, who is the global coordinator for FAO's ScaleWatt project. We were NOWatt for the first 3 years. We're ScaleWatt now, and of course I joke, next is going to be SOWatt. On responsible water tenure governance, he joined FAO in 1999 and focuses on land management and governance, and has served as FAO land and water officer in both in Latin America and the Caribbean, and as an expert consultant with the German government and Adelphi. And so we have hopefully also him online, but we'll listen to his presentation and then we'll open up for the rest of the time to questions.
Thank you very much for the opportunity to present the global dialogue on water tenure in this very important session. Thank you very much, Jess, for putting this together, and thank you very much to the University of Nebraska to organizing this very important Water for Food Global Conference. My name is Benjamin Kirsch. I am project coordinator at the Food and Agriculture Organization of the United Nations in Rome, and I prepared this presentation together with my colleague Sofia Espinosa, who is Land and Water Tenure Specialist. I would like to start giving you some global figures that make the case for the responsible governance of water tenure. On the whole globe, we have about 10% of the world population which live in areas of high and critical water stress. Agriculture alone accounts for 70% of global water abstractions and is the sector which by far abstracts most water. And this trend will continue. FAO thinks that until 2050, a projected 25% increase in global water demand is necessary to feed a growing population. In many regions, climate change alters water availability already to this day, and this is also projected to increase. We have a situation where a lot of times land and water rights are interconnected, and this means that land acquisitions also often include the appropriation of water resources. And at the same time, many smallholder farmers, fisherfolk, and pastoralists depend on customary water rights, which may or may not be accepted or recognized by formal laws. So the issue of fair and sustainable water allocation has never been more important. And as you can see on the right, this is valid in all regions of this world. Water tenure has been on FAO's agenda since about 2012, and it all starts with this document that you can see on the upper left, the voluntary guidelines to the responsible governance of tenure of land, forest, and fisheries resources in the context of national food security. This document lays out basic principles for a responsible governance of access and use of land, forests, and fisheries. Now, water was not included in that document due to several reasons. One of them being that water tenure was not very well understood as a concept. But FAO continued exploring the concept and started working on assessing water tenure arrangements in several countries with several expert consultations. And finally, in 2022, the Committee of Agriculture, another of FAO's statutory bodies, in its 28 sessions, discussed the topic and recommended FAO to initiate a global dialogue on water tenure and encouraging members to participate in the dialogue to identify principles for the responsible governance of water tenure. And based on this recommendation, FAO organized expert consultations on mapping out a roadmap for this dialogue. And in 2023, at the UN Water Conference, FAO included the global dialogue on water tenure as one of its 8 commitments to the water action agenda. Later on that year, we had a global expert consultation on the roadmap for the global dialogue and started the ScaleWatt project funded by the German government to support this process. Last year, in July, COAG 29 reaffirmed the mandate on the global dialogue. What is this dialogue about? The draft objectives of the global dialogue on water tenure can be summarized as follows. It is about building a set of non-binding principles for the responsible governance of water tenure, to build consensus around these principles through multi-stakeholder consultations at different levels, build eventually criteria to guide the implementation of principles for states and non-state actors, and build capacities of countries and non-state actors to apply these principles. As I mentioned earlier, we have worked a lot on a roadmap for the global dialogue, and these are the 6 phases that we have identified. It's important that these phases are not necessarily one after the other, but some activities can be concurrent. We are at the moment finalizing the preparatory phase with the preparation of background papers and basis for the consultations. We're also involved in phase 2, technical support and coalition building, for example, through an expert group on water tenure and consultations that we have with different actors. Then we will now go into the 3rd phase, which are the multi-stakeholder consultations at different levels, at country level, regional level, and eventually at global level. Then there will be a phase of compiling results and drafting the principles document, a 5th phase of political endorsement by a global conference or, for example, the Committee on World Food Security or another global body, and finally a 6th phase of implementation and monitoring of the principles. FAO is supporting this process through various activities at a global level. We have an expert group on water tenure, which brings together about 20 actors, among them Environmental Law Institute, IMI, the Water Integrity Network, the Nature Conservancy, the World Council of Churches, Water Witness, the Special Rapporteur of the Right to Water, which advises FAO on documents such as the roadmap. We do advocacy in global events such as the World Water Forum and World Water Week, the UN Water Conferences, side events to Committee on World Food Security, etc. Provide conceptual advice through the drafting of the roadmap and other discussion documents, and articulate this initiative within the FAO and as well as other UN agencies, civil society, academia, and the private sector. FAO is also working at country level to understand what different water tenure arrangements exist in the countries and at local level, and based on this water tenure assessment, as we call it, starting local and national consultations on responsible governance of water tenure, to see how water can be better allocated, how customary rights, for example, can be better recognized or included in formal rights systems. And we have worked in several countries around the globe, in Colombia, in Senegal, in Rwanda, in Sri Lanka, Thailand, Vietnam, Cambodia, and Indonesia through different initiatives. In this current phase on the project, which I mentioned in the beginning, funded by the German collaboration called Scale What, we will also organize first sectoral consultations in Latin America and Asia. And through the Spanish cooperation, there is a consultation that will be going on next year in West Africa on pastoralists' water rights. And finally, all these inputs will feed into global consultations. If you want to learn more about our work, I invite you to access our publications, which are all freely available online. I just would like to mention three here. First, our Water Tenure Assessment Guide, which is available in English and Spanish. Our publication Water Tenure Perspectives, which unites about 20 articles from all over the world, different perspectives on water tenure and how it is useful in different countries and contexts. And finally, Promoting Water Tenure for What's Food Security, Climate Resilience, and Equity, proceedings of a seminar that we did in 2022. I would like to close with an invitation to engage with us, to engage in the global dialogue on water tenure. And this can have many forms. You may join our expert group, our consultations, or listen in. The next consultation on the roadmap of the global dialogue will be 27-28 May in Rome. You may be interested to organize dialogue events on water tenure or consultations in your country, region, or sector, or do a water tenure assessment. Become a resource partner. Please just drop us a line. You see my email address here, or participate in our survey by just scanning the QR code that you see here next to me. And with that, I would like to thank you for your attention. Thanks again, Jess. Thanks all the other presenters that have been here, and I look forward to receiving your questions. Thank you.
And if you can hear us, thank you. So I know we're running a little bit more behind time. We took a little time for questions early on, but I want to open it back up to you all and see if you have more questions or comments. Over here.
Thank you. I was just curious, so are water rights and water tenure policies reactive to efforts to increase water supply? Mainly, I'm just thinking about aquifer recharge, especially I know in Arizona, there's been a lot of efforts by the ADWR to recharge some of their aquifers. Yeah.
That's me, huh? Yeah, I mean, I would say that's a very kind of, it's a very place-based specific question. So to be honest, I don't know the ins and outs of Arizona water law. I think that might be more for Cora to answer. I don't know if you have, yeah.
Yeah, and is this on? Can you hear me?
Go ahead.
Okay, I don't. I think it works in concert with, so those that do have water rights established are of course protecting, but largely in Arizona, about 80% of our population lives within the Phoenix metropolitan area. So a large portion of Arizona is rural, and the current groundwater management laws that we have are for those urban areas. So a large amount of Arizona is unregulated. Those water rights holders that do have their rights quantified and secure do have those protections in place. The tribes that do have settlements in those regions do have some groundwater management plans, not all. So they do use that, but it's more of a, I would say, a defensive approach. I don't think it's more of, I guess in a sense it is, in that they're trying to protect the water for the users now, but I think the trend in Arizona that we see is that we're trying to plan 100 years into the future, so I think it's also more in that realm as well. So I think it's more of a balance, but I do see that the conversation in the water policy community is looking more to the future and recognizing that our groundwater is depleting, and so making sure we're making correct land use decisions to protect that resource in the future, especially with the conditions on the Colorado River and the shortages there. There's seen that, I think that shift into how the state is going to manage our groundwater resources in conjunction with the decrease that we're receiving from the Colorado River, which is about 40% of the state's water use. So it's a big conversation.
Thanks so much, Cora. I would just add that it is a big consideration, because many countries, and Jude, I think you can speak to this as well, that we don't see conjunctive use reflected in a lot of water laws. There's very few groundwater provisions in a lot of the framework water laws. Sometimes they're still separate laws governing certain aspects of it. Really, it's regulatory and based around permitting, borehole drilling and those kinds of things. So one of the things that we're actually trying to get at under the principles is encouraging more conjunctive use as a mechanism for being able to make those decisions and trade-offs and account for the resource as a whole. So it's an ongoing challenge, but it's one we're tackling slowly. Anyone else have a question? Comment? Please.
In case of Arizona, when you have, for example, in a indigenous reserve, you must have a permit to use the water. How it works? You have a main governance inside this reserve, and what kind of regulation do you have, considering the water tenure?
Mm-hmm. So as I mentioned, Arizona has 22 tribal nations. All but one has a reservation. So with this Northeastern Arizona Indian Water Rights Settlement that is currently in Congress right now, if that is passed, that would establish a land base for that remaining tribe. But each tribe has its own government that they manage their water resources from. It does work in conjunction with state, like the Arizona Department of Water Resources, so the state water regulator as well. But because they're federal rights, some tribes do have state-based water rights as well, so they work within that state-based paradigm. But mainly the water management is is managed by that own tribe's government on their lands, and also by federal law as well. So it's a complement of federal law and specific tribal law to that specific reservation and tribe.
Thanks so much, Cora. I think we have time for one more question, then we have to wrap it up. Anyone? We can wrap up early. We have 2 minutes left. Going. Oh, you want to ask a question? Yay, she has the mic. Oh, and then we have one back here. Woo, okay.
Do you have examples where it's working well?
What
could you
is
share?
working well?
Well, water tenure, the governance, any examples like success stories that maybe, could be implemented elsewhere? Of course, it's all context specific, but,
Yeah. Well, it's interesting because when I say what, I think there's so many different aspects of water tenure that you could talk about, and you're not going to necessarily get like, they're doing it great in this country from every perspective. But you do have, for example, Ecuador, who is kind of a global leader in recognizing women's water tenure rights. That's the one country that we keep talking about, We have this Atrato River decision where you've got the role of the courts really stepping up and saying it doesn't matter if the government has legally permitted these bad actors, human rights are more important, indigenous rights are more important. You have in Latin America, I think we can learn from a lot of the territorial and indigenous recognition that's developed over the last years. Because we don't have a lot of self-identification of tribes and other local communities in sub-Saharan Africa as indigenous, the really hard-fought and won rights for indigenous peoples around free, prior, and informed consent, territorial integrity, having more of a situation where you might be able to have sovereignty within your own territory around water management and governance to enable the kind of system that Barbara was talking about, these kind of more hybrid systems where you can kind of say, we recognize what you're doing, and that can be part of the overall system. We don't have that in a lot of other places because we've only focused on indigenous, and there's still so many struggles there. I'm not going to say that that's working without any problems, and it continues to be an issue. Cora raised a lot of those issues, but I would say there's pieces and there's different tools that we're seeing for different aspects of it that are really promising, and I think that's why these assessments are so critical. That going into it, you could say, well, we know lands and water are connected, but we didn't know how we didn't know that if you go to Liberia, you don't have any water rights unless you have them under the Community Forestry Act, right? Like now they have a new land act. While we were doing it, there's actually some under the Land Act too, but there's no water law that says any communities have rights, right? We didn't know that that so few women, you think, well, we've done so well at recognizing women's rights and there's global commitments and there's global treaty, but we're not implementing it in any way, shape, or form. And the water sector needs to step up. Water laws are really falling behind. They're focused on technical aspects of it. They have not been focused on social equity and inclusion. So I would say that, where we start to see those pieces, we really need to start getting that evidence and encourage countries to do better. Okay, well, I think with that, we have to wrap up, but thank you so much. This has been such an engaging conversation and such good questions. Thank you for coming and listening. And I would echo Ben's sentiments. Please come find me if you're interested in getting more engaged in this sort of global dialogue process or in joining the experts group. You don't have to be an expert. You can come listen to sort of what the sharing of materials are. We usually do online meetings every couple of months, and it keeps getting bigger and bigger. It's really exciting. And yeah, thank you so much for being with us today. And thank you so much to Chloe and to Cora for your great presentations and incredible insights.